WDXE News, on the air since 1950.
We've made it to bulletproof planning. That's right, bulletproof estate planning.
That's right. Good. We are here
with Stan Pierchoski, and of course, always on Fridays. And looking forward to a good visit with you. How are you, Stan?
Oh, pretty good. Friday came up. I don't know if it came up fast this week, but it went slow. Well, pretty quick.
It met me pretty hard this morning.
Did it? Well, that part's different. I mean, it's just sometimes you feel like, God, we were just here.
Yeah.
And sometimes it's the other way around.
I'm happy that it's Friday.
I am too.
Yeah, I'm happy that it's Friday. That's for sure.
So, yeah. Well, good morning. Good morning. Hope it's a decent day. It looks like it's going to rain over the weekend, but boy, then temperature's going to jump on up. It's going to be.
Yeah,
we're getting spoiled because it is July.
It's July.
In July, what do we get? We get hot weather.
It's summertime. That's right.
Yeah, I mean, so we can't be surprised. We might be a little disappointed the cool weather didn't last any longer, but it sure can't be a surprise.
That's
it's going
right.
to be 90-some degrees on the 4th of July, right?
It's supposed to be hot.
Yeah.
It's supposed to be hot.
Well, my daughter's moving back, and she'll be here Tuesday.
Oh, I know you're excited about that.
We are. Well, I'm excited about them coming here, but I've got a list of things that got to get done, so I'm not 100% prepared. This weekend it'll be pretty. I'll get up early and be going to bed late, because I have a list and now it's prioritized what has to be done and what can be done after they're here.
Yeah.
The little kids in the house. They come to visit a couple times a year, so we got basically childproof, but. I have a swimming pool in the back, and it's got a deck, and when you have a wooden deck over the time, especially with a pool, there's about half a dozen places where I might have to replace a board.
Yeah.
Because when you buy that wood, every now and then you get one of the boards in there just kind of goes south on you.
Yeah.
It's just stuff like that.
Yep.
But
are you a list maker?
I do when I've got to get a bunch of stuff done. Because I don't want to forget about them. I can multitask pretty good, but sometimes if I don't write it down, I'll be 3/4 way through the day and think, oh darn, I needed to do that.
Yeah, on occasion I've made lists over the years. I'm not regular at it. But when I have done it, I seem to get more done.
You know what's funny about a list? I think this is human nature. If you're listening, you've probably done this, and it'll crack you up. Let's say you make a list, and there's 5 things on there. And you're doing them, and all of a sudden, you do something that's not on the list.
Yes.
And I'll bet you 99% of people write it on the list and then draw a line through it.
That does help your feelings.
It does.
It helps your feelings.
It makes you feel better, but it's ridiculous. It's like, okay, you get that sense of accomplishment.
That's right.
It's like, well, I should have put it on the list, and if I had put it on the list, I'd be crossing it out. But if it's not there, I want to get credit for that task.
That's right. It's
like somebody's going to look at this list.
It's just mental credit. You just got it.
Like somebody's going to look at the list when you're done. But that's funny. But hey, let's see. Let's talk about our seminar coming up, because you know what? Every week it gets closer.
It does get closer.
Isn't that amazing? So here we are on whatever today's date is, 26th, I guess. And we have a seminar just about a month out. It's going to be July the 25th. So it's a Saturday.
Yeah.
And that's going to be right here at WLX radio station. At 10 o'clock. We do our Saturday seminars at 10 o'clock in the morning. We call it Wills, Trust in the Nursing Home. And that's what we'll be talking about. And not too early to RSVP for that. We got a good venue here, but the last time we were here, we ran out of tables and had to just put some chairs out and give folks some clipboards because there were no more tables. And here they got round tables. And when you're doing a speaking event, it's hard to utilize the round table. Because people are not going to sit with their back toward the speaker, and then they kind of huddle on one side of the table, and you only get so many in. But it is what it is. But it is still a big venue and plenty of room. So anyway, so we will have that, and I'll talk more about it. I was going to talk about something we were talking about a little bit off mic, and let me tell you, I do a lot of TennCare planning, right?
Yes.
And I deal with them all the time, and TennCare, I'm trying to be as gingerly as I can, and they're a difficult organization to work with. Not as sure exactly why. I have my feelings why. I mean, people come and go. There's a lot of attrition. When you talk to somebody, sometimes when you're dealing with a case, it's hard to speak to the same person twice. But when you get a caseworker, they're supposed to stay with it. And I got a case we're doing something on, and here's something they do often. I don't know how they manage it, but this happens a lot.
Yeah.
And that is when you file a TennCare application, you're waiting you know, I don't know, somewhere around a month in or so, you'll know that when they actually assign a caseworker to it, because they will reach out and have an informational request and ask for stuff. And typically the first ask is pretty boilerplate. It's like updated bank statements between the time you filed the application and now, stuff like that, okay?
Yeah.
And so they'll ask for that. And when they make those informational requests, you know, you need to respond to them, because if you don't, they can deny the application for failure to respond to an informational request.
Yeah.
Well, what they do a lot, at least, I can't believe for a minute they just do it to me, but I don't know about other cases, right? I only know about mine, but I can't.
Right.
If they do it to me often, they must do it everywhere often.
Yeah.
We'll get, you know, we have a system in place. We have all these I know the questions they're going to ask before they ask it. So we gather this documentation, and then they will say, "Can you please just send us this, this, and this?" Okay. Sometimes it's an email, sometimes it's a little more formal, but basically, usually it's kind of informal. But they'll send you a list, something you can rely on.
Right.
And so they send that to you, and it's typically one of their 10-care letters, but sometimes they follow. Sometimes they'll send it to you email request ahead of time, because the letters are usually a few days after. You know, they got to generate the letter and mail the letter. And so, and then you only have so much time to respond. And so we have a system where we gather documentation, knowing the questions they're going to ask, so that when they ask them, we can just send that stuff to them. And everything's electronic. You know, scanned versions. We don't need to send them physical paper. And so, in this case, like many cases, they'll ask for something, we'll supply it, and then they'll say, we didn't get it. And now, when you deal with TennCare, it's a lot with fax. We deal with them with fax. They have something called a TennCare portal where you can upload stuff, but boy, that thing is just a giant cluster. I mean, we don't use it because it's so unreliable.
Right.
So we fax it to them. And we have a sophisticated fax that shows not only that we sent it, shows it where we sent it, and it shows you like a miniature copy of the text that we sent, the content of the document. And it will tell us that a confirmation that the TennCare fax machine received it.
Yes.
And so here's what has happened many times. We send it to them, and then after we send it, we get the confirmation. Then we'll call the caseworker, email them, and say, did you get it? And on many occasions, they'll say yes. And then all of a sudden, we'll get a letter from them that says, your application has been denied for failure to respond to an informational request. To which we say, you know, the hell you say, we got all this proof, right? And so this happens often.
Yeah.
I mean, often. I'm going to say 1 out of 3, if not 1 out of 2. That's somewhere along the line. And so what we do is we call them and try to convince, and say, here, I sent it. Here's the fax. Here's the confirmation. Now, if we get somebody who's cooperative, they'll go looking for it. And I'm going to say half the time, they'll say, okay, yeah, we got it. Sorry. Sorry, our bad. And then they kind of withdraw the denial. Okay?
Yeah.
Half the time. If you get somebody that will reason with you and talk to you.
Yeah.
But that doesn't happen all the time. So, and when it doesn't, we have to, you know, as soon as they say we're denying you for failure to respond to an informational request, we file a fair hearing. You know, we request a fair hearing. And every single fair hearing I've ever done, well, first of all, I've been successful in every one we've ever done. But every one I've ever done where on this issue, we've always been successful because even if they can't find it, we can show that they got it. Now, I don't know what happens to stuff over there. It's some kind of Bermuda Triangle fax machine or something where when you send something, it just goes off into the ether or something.
Yeah. I
actually had a case one time where during the hearing, okay, this is a order.
Yeah.
It was a married couple, and the husband was in care. And we sent stuff. And they dug their heels in and said, no, we just have to go to hearing. You didn't send it. I said, but we can prove we sent it. Don't you even want to see the proof? No, you show it to the administrative court. So we get to the hearing, we show it to the administrative court. And the court was leaning heavily towards saying, well, they certainly carried their burden. They did everything possible. When you send stuff to fax, you tell them how to fax it. You give them the number to fax it to. They did that. They can show proof that they got it. We can see the documents that they sent. They're the ones you asked for. And there's confirmation that your machine accepted them. That's the court after looking at our proof.
Yeah.
And they said, give us a minute, Judge. Something just came up. And so the call is telephonic, right? And so they go mute for a little while. And then they come back on after waiting about 5 minutes. They say, oh, wait a minute. Oh, so, our bad. We found them. They were in the wife's file, not the husband's file. Now, first of all, I say, why is there a wife's file? Because the husband's one we're getting eligible, right?
Yeah.
So it was just, I probably shouldn't go out on a limb to say this, but it's got to be just a false statement. It can't be, they don't just do that. And then
they were covering their tracks.
Then when they get themselves, in a sling, Now they got this, oh, sorry, yeah, we found them. It's like, yeah, okay, it's been 90 days since we asked for, because when you ask for fair hearing,
Yeah.
they tell you when it's gonna be. You don't, it's not like regular court where you go in and compare schedules and find out when's the next time we can have a hearing. They'll notify you in 90 days when your hearing is. And you never get it before day 90, ever. So 3 months went by, dealing with the nursing home all 3 months because nobody's getting paid, right?
Yeah.
And so so I've got a case now where they did the same thing, and we appealed it. Okay, now get this. This case is just such a cluster, and it's not on my end, although I'm getting blamed for it. But so we filed for fair hearing, and we know we're going to be successful. First of all, because we always are. Second of all, because we got all the proof necessary to show we did everything we could possibly do on our end.
Yeah.
There's nothing left to be negligent or something we didn't do.
Right.
And so we get to our hearing, because we couldn't talk them into it ahead of time. You get a hearing, here's how a hearing works. They're all telephonic with the administrative court, right?
Yeah.
And they call you. You cannot call in, okay? Because they'll say, we will call you between 1 and 4. Or like, well, we call you between 8 and 12
Yeah.
for your telephonic hearing. And you're not allowed to call in, because if you do, they won't answer, because they'll call you when they're done with the case before. They got
Right.
a couple scheduled per session.
Sure.
And you never know when they're gonna begin and end.
Right.
And we've even had some where they call us and say, look, this case took tons longer, we're gonna have to put yours on another day, because it's the end, we're done, right?
Yeah.
But, we're required to sit by the phone and wait for it to ring. Okay, we do that. Now, we have a sophisticated call log on our phones, and we have it for this reason. And so we get to the hearing, and I can't remember if it was between 1 and 4, 8 and 12, it was, let's say 1 and 4. And we have the person, the person that's gonna talk to them, the authorized representative that's gonna argue the appeals, waiting by the phone. Okay? And it never rang. And there's nobody for us to call and say, hey, are you gonna call us? And if you did, you wouldn't get through, because you are not permitted to call in.
Right.
And so, after 4 o'clock, we try to call them and say, hey, we try the caseworker, and say, hey, we had this appeal, or the appellate division of TennCare. And it was, of course, it was after 4, now they were closed, right?
Yeah.
So the next day, we get, your appeal's been denied for non-appearance, like a no-show.
Yeah. Yeah. Like you didn't show up.
And so like we here on my side, we got together and we pulled the call logs and said, and the call log will show an incoming call or an attempted incoming call, an incomplete call.
Yeah.
And it wasn't there. It just wasn't there. And that's why we have that. And so, we appealed that.
Yes.
Now that's still yet to have that hearing. But as we move forward, now there's other things we'll do when that happens to try to get to the approval or something.
Yeah.
Like in this case, we'd like file another application and move along with that one. And so, but that's still up for appeal. And when it comes up, it can only go one way, my way, because we have all the proof. There's no way they can combat the proof that we have.
Yeah.
But then you got to look at it from the outside view. It's like, oh well, you filed an application, it got denied, and then when you appealed it, you never showed up for the hearing.
Yeah.
It looks really bad, right? Because
Yeah.
you don't know the whole story. And this is the kind of stuff that happens often. This first time the no show on a telephonic hearing happened.
Yeah.
That was a brand new thing. But they are so non-due process. I hate that about them. They're a government organization. They should at least be fair. And they're not. And they usually aren't. I don't know and I can't tell you if they train people to do that or not. It's just another reason why you need an advocate to do it, because if you're doing it yourself, they'll just run roughshod over you. But anyway,
Yeah.
we have our remedies at law.
It seems terribly inefficient.
And then all of a sudden we'll do a case and it'll just go through like, grease lightning, just slip on through, no hitches at all. And I just wonder. Sometimes I'd like to be a fly on the wall.
Yeah.
To see, because I'm just absent explanation why it gets this way.
I think I may have asked you this before and you may not know, but do we know how many actual employees there are with the TennCare system?
I do not. They have regional and local facilities. I do know they come and go a lot,
I would think that just based on what you've told me that it all depends on whose lap it lands in.
That's true. They can't get a lot of training. It takes a lot of training to understand this system.
Yeah.
Now, it's true. You get somebody that can be very helpful,
Yeah.
talkative, kind of useful in trying to resolve any issues like that.
Mm-hmm.
you know, like, hey, we sent the fax and you said you didn't get it. So they would say, okay, well, let's see, where did it go? You know, if you sent it, then, okay, it's gotta be here somewhere. Or if it's, hey, it looks like you sent it, I don't know where it is. It came here, but I don't know where the heck it is. Could you please send it again?
Yeah.
Stuff like that. They'll work with you. Then you got some people that just arrogant. They just say, you know, denied. And you say, well, wait a minute, let's think, can you go look for it? No, I've already denied it. You can argue it at the hearing. And and shut you off, cut you off. I mean, there's not much you can do when they do that. You can't, you know, it's an adversarial system and you can't make them do anything. But I mean, you know, there's the duty of good faith that's in all proceedings, duty of fair play and good faith.
Yeah.
A lot of times I just feel like we're on the wrong end of the stick on the duty of fair play.
Yeah.
Because we do everything we can for them, and they just do hardly nothing, or it's just so haphazard or sloppy. I really don't think it's by design to hurt. I mean, I really don't want to think that, you know what I mean?
Yeah.
But I really think they just don't know. It's just they're bigger than their britches, so to speak. You know.
Yeah. Yeah.
Things go on, and they just. But anyway, that happens a lot, and it's going on now. So
Yeah.
anyway,
Yeah.
it just kind of makes me sad sometimes. It hurts my feelings.
Well, do you want to take a call?
Always up for a call.
All right.
Seeing as how it's one of those interactive.
All right.
shows.
Well, you have made it on this morning.
Well, he's talking about something right that one is in Tennessee, a friend of mine. The other one is in Alabama, similar, but I want to cover them separately because they tie together with Medicaid. All right, the one in town, her sister is on Medicaid, and she was going to sell the car. And her understanding was she could keep a car, and I was wondering, was that true? Even though she's in a nursing home and never will have to come home again. But now she's having now she has an attorney, but she was excited. I told her I'd try to call about this. If she sells the car, then that's money. And she thinks there's a way, without putting in a separate account, that if you spend it on the patient's to increase their living, you know, in other words, if she spent that money for her car, it's going to be about $5,000 or $6,000. It might could go for things like a nicer wheelchair, clothing, possibly even paying sitters to go check on her because this person has health issues herself. And so my question about that is her thinking correct about that? And because another issue is, she says, this is the way I was thinking too, since I have no children, I wanted to put her in the will to leave her some money. So my guess is that would fall into something similar to the thing too, is it would have to be used some way to benefit the patient's quality of life. Okay, I want to leave her. Did he understand what I was saying?
I do.
Yes, we do.
Okay, the other one is in another state, and she's in a similar situation with a car there. And so whatever you answered the first one, I can apply to that. But her situation is real estate. 2 houses are owned. Both husband and wife have just entered a nursing home in another state, but it's equivalent to TennCare here. It's Medicaid. And they've got their real estate outside of a trust. And the parents' names are not on the trust. It's just the children's name. The attorney told her that just because they have a life estate in the home and possibly in the so-called rental property, that that may not end just because they're in a nursing home. That there were, and that it's different if it's a home versus a rental property. And I just wondered if he could touch those two things in terms of here in Tennessee, so I can kind of give her feedback. Does that make sense?
Okay, I think we'll make some sense out of it. Okay.
Okay.
All right.
Well, I would caution her to give them feedback because, you know, you get in trouble giving that kind of advice.
Yes.
But one thing, but I don't know what I'm going to say about the Alabama because Alabama, I mean, it's Medicaid, but every state has their own version of it, and the rules are different. They're not similar. They're not that similar in Alabama as they are to Tennessee. But let me talk about the car first.
Okay.
You know, when you're becoming eligible for TennCare, you cannot own much property, and so it falls into several classes. But one of the classes is called exempt assets, and a car is one of them. And the statute pretty much reads and says you're entitled to have one car regardless of value. Okay. So if people have two cars, they'll probably claim the more valuable, the nicer, more valuable one as the exempt car, and the other one represents just an asset. Now, she talked about. She goes, well, she said, well, she's got this car, but she'll never ever drive it or ever be in it, something like that. That's not the criteria. The criteria is that you can exempt the car if it's the main source of primary vehicle for the patient or the patient's family when they come and visit.
Yeah.
So you know they're pretty loose on the criteria. You can have one car regardless of value, and so. Now, that is an exempt asset. So whether it's worth $5,000 or $15,000, or maybe it's a nice truck worth $35,000, right? It's not considered a countable asset. It is a exempt asset, right? Now the question is, if let's say you have a $10,000 car, I like these round numbers on the radio. If you have a $10,000 car and it's exempt, if you sell it, you get $10,000 cash. Okay, so I'm telling you that $10,000 is not exempt. And the question comes, well, wait a minute. If I give the car away, it's like, well, the car's exempt. They're not using it against me for my countable assets in the first place. So what exempt means is that $10,000 for the car is not in the equation when they're TennCare determines whether you're financially eligible. That's $10,000 that's not a non-countable asset, and you only can have so many countable assets, right? So that's out of the equation. $10,000 is just not even in the figuring when they decide if you're eligible or not. But in the theory is, well, if I give away my exempt car, there should be no penalty for that because it's exempt anyway. You're not counting it. Well, that's not the way it's treated. It is. If you give it away, now it's considered a gift. But it's exempt. I gave away something exempt. Well, it doesn't matter. The rules say if it's a car, it's exempt. If it's your primary vehicle, and it's exempt. But if you sell it and get $10,000 of money, the money is not. And if you sell it, you are now over-resourced because you're only allowed to have $2,000, right? Yeah. Now, one of the things she said was partially true. You can spend that $10,000 down on certain things that you can purchase. You know, medical supplies, expenses. There's like home improvements, pay down debt. Buy funeral arrangements in advance. There's a bunch of things you could spend it on. The wheelchair, like she mentioned, would be okay. Yeah. But you're kind of playing with fire because there's a time limit on it. Because if you sell that, I'm trying to remember the statute, but if you sell it and have $10,000, if you still have that $10,000 cash, come the first day of the next calendar month, it's now considered a resource, and you're going to be over-resourced, and you can damage your eligibility. Yeah. So. The car is exempt. The cash money for it on a sale is not. So you have to deal with it just like you came into $10,000. Yeah. So you've taken a non-countable asset, an exempt asset, and turned it into a countable asset. I would never advise people to do that. I have people say that mom's in the care, car's just sitting there for 3 years. We can't get insurance on it, I don't know why, for some reason, but they said it's just sitting there going to waste. Can we sell it, or can we give it, or can I have it? I say, well, use it all you want, but don't sell it or give it away. If you sell it, we got to deal with the money. If you give it away, it's going to create a penalty period because that's a gift. And so, and if you can call me all day long and say, well, that's not right. It's an exempt. Don't ask me that question. I'm telling you the way it is, not the way we think it should be or the way it makes sense. They specifically say the car is an exempt asset. If it's a car, and they qualify it as one vehicle regardless of value. But if a second car is an asset. You would have expected to sell that car and use the money to pay for your care. Sure. So, so that talks about the car if you give it away, or the car if you sell it and get money. Okay. So, would be my recommendation: just leave it. If they're not using it, let the family use it. I mean, don't let it sit there and go to waste, but let the family use it. I don't know why you can't get it insured. Insurance companies don't insure anything, right?
If you pay them enough.
That's right. That's right. There are a few things that are uninsurable. Yeah. But anyway, so now the one in Alabama, I'm qualifying it with I don't practice Medicaid eligibility in Alabama. I understand how some of the rules are, but you got two houses. I can only equate it to Tennessee.
Yeah.
And there are a lot of similarities with Alabama, but they do have their own set of rules. Just remember the thing I said before, previous show about having one big bubble and inside it there are 50 different bubbles?
Yes.
I said the Medicaid Act the Federal Medicaid Act is the big bubble. And then the 50 bubbles inside that bubble are the 50 states who can all have their own system as long as they don't escape the big bubble. They got to be within they have to be within the Federal Medicaid Act.
Right.
But there's different things you can choose while you're in the Federal Medicaid Act. And so you got 50 little bubbles inside this big bubble. Now, some of the little bubbles, first of all, none of the little bubbles can escape the big bubble. Okay, the federal law
Right.
has the boundary lines. But the 50 bubbles inside can overlap, and they do. Some overlap a lot, and their rules are similar. None of them overlap completely because basically there's 50 sets of rules.
Right.
And some of them don't overlap at all.
Right.
Now, Tennessee and Alabama have some similarities. Okay, not completely the same, but there's similarities. So let me just kind of look at it from Tennessee law. And if you got two houses, she's right. They fall into two different classes.
Yeah.
One class of real property is the primary residence. Primary residence is defined just like you think it would be, where you live.
Yeah.
Now, there's also some things that say your primary residence is where you live and any contiguous property.
Right.
So if you've got 1 acre and a house on it, that's your primary residence. If 100 acres opens up right next to you and you decide to buy it, and it shares a border with that 1 acre, the whole 101 acres now is your primary residence.
Right.
Because now, the only other piece of real property under the 10 Care Act is other real estate. Other real estate is defined as there is a third property owner between you and that property. So it's not contiguous.
Right.
So you own lot 1, Joe Blow owns lot 2, and then you own lot 3.
Yeah.
That's other real estate. Now, sometimes you'll hear people say, she didn't bring this up, but you'll hear people say, especially facilities, they'll say, your house, your residence, your primary residence is protected.
Yeah.
Don't worry about this, protected.
Yeah.
Not a true statement. Protected is not the right word. I strenuously object to the word protected.
Yes.
It's deferred.
Yes.
So what they're saying is, okay, now the primary residence is not an exempt asset, it is an excluded asset. It's like, okay, big deal, what's the difference, exempt, excluded? Well, it is a big deal, there is a difference.
Yeah.
Excluded means it's a countable asset, exempt is not countable in the first place, okay? Exempt, your primary residence is a countable asset, but you can exclude it from the calculations when they determine your eligibility. So think of it this way, like a ledger sheet. You take your $300,000 house out from under the countable assets column, you put it over here in the excluded column, right? Mm-hmm. And that's something you can do under the 10 Care rules. Ownership didn't change, you didn't monkey with the deed or anything, you just put it over there. So now when they figure out how many countable assets you have, the $300,000 countable asset of the primary residence is not in the equation because it's been excluded from the math.
Yeah. Okay.
Okay, so maybe now you're eligible. Okay, let's just say taking that out of there it makes you eligible. 10 Care will pay your bill while you're at the nursing home. And so at your death, there's something they exercise called estate recovery. It's called the 10 Care State Recovery Act, where they go after whatever's in your state. Now remember the primary residence? Didn't go anywhere. You still own it. They just didn't use it against you for eligibility purposes. Now estate recovery says, we are coming after that to get back paid what we paid for you while you were in care.
Right.
So when they say it's protected, that's not the right word. It's misleading. And people just don't do anything with the house because it's misleading.
Sure.
Because it just means they're going to come get it, just not yet.
Yeah.
And God bless them, if you pass away and they'll put a lien on your house, and if your spouse is still living there, God bless them, they will wait till your spouse dies before they'll go get it.
Yeah.
Isn't that big of them?
Yeah.
And there's a couple other exceptions. You have a minor child or a disabled child living
Sure.
there. I mean, there's certain, but anyway, so when you have two houses like that, that's how they're categorized. The primary residence or other real estate.
Right.
The other real estate enjoys no preferred standing whatsoever. It is a pure countable asset. Like, so if you have a other real estate that's worth $100,000,
Yep.
that's like having $100,000 cash in a bank account. That is countable, it's available to, and they will expect you to use that to pay for your cost of care.
Yeah.
You will never become eligible with owning that piece of property, because when they count up your countable assets, that's $100,000 of it, and that's over $2,000.
So they would expect you to liquidate that.
Yep.
Turn it to cash.
Or do something with
and
it.
pay for your estate.
Or that's what they would expect you to do with it. Or what the rules say, you can turn it into a non-countable asset, but you gotta do something with it.
Sure.
You can't just let it go. And she said both husband and wife were in care. Okay, I'm not sure that can enter into the equation about what we would do with that property, but that wasn't what I was asked, and I'm not gonna go into that because it's Alabama. But, she said something about the real property being outside a trust. Now, I would assume when it's outside a trust is when it's a problem. So the whole, everything we're
Right.
talking about is assuming it's outside the trust.
Yeah.
But they have a life estate.
Yeah.
Now, you can't have a life estate on the rental property, but they could have one on the primary residence.
Yeah.
So if I try to break this down with the limited facts I have, they may have a primary residence that they've given to the kids, because she said the kids' names were on it.
Mm-hmm.
So she's given it to the kids, and they reserved a life estate. Now, when you think about that, what they did was give some of it away. It's called the remainder interest. You're familiar with those terms, right? The
Yep.
remainderment, right?
Yep.
The remainder interest is the future interest. And that's what they've given to the kids. What they retained for themselves when they said we reserve a life estate, they retained the present possessory interest. You know, when you have own real estate, you got this bundle of rights.
Sure.
Those are two of them.
Sure.
And so they have the right to live there. But when you do that, that has a value. You go to the Title 42 and the Social Security tables. There's a life estate table.
Yep.
It's like, okay, what was the value of the life estate? Well, we go to the table. We go down to your age. You go across the table. I'd say you're 65 years old when you do
Sure.
this. Let's make it 75. You do this, and you go across, and there's two columns in this table. So
Yep.
two and only two. One is the life estate value, and the other one is the remainder value.
Okay.
And they're two decimals. If you add both the decimals up, you get a 1. They add up to 1. 'Cause
Right.
they're percentages, right? And so usually it works out to be that the life estate is about 40%. Now you got to go back in time and see what was the value of the property when you made that life estate. And that, you take the value of the house, you multiply it by the life estate number, that's the value of what you retained. You multiply the remainder fraction against the total value of the house, and that's what you've given away. So if you go into care in this next 5 years, that's a partial gift based on what you gave the remainder.
Right.
Now, the retaining the life estate, I know in Tennessee is not too big of a problem because the life estate is treated like the primary residence. And the advantage of that is it's not going to be subject to estate recovery because the life estate expires worthless at death. Okay?
Yes.
So, but the other but the remainder is you haven't given them all the property. The owner at the death of the life estate, the remainderman now has all the ownership, both the future interest and the present possessory interest, because the life estate, which was the present possessory interest, has expired. Now, talking about two houses, none of that works for the rental property she mentioned.
Right.
You can't reserve a life estate in a rental property.
No.
I mean, you could if it's the primary residence, but I have trouble reconciling the fact that if it's the primary residence, how's it a rental property?
Yeah.
So, but there's probably some ways to work around that, but let's just take it in its basic form. So that's going to certainly qualify as other real estate. The only way it can become part of the primary residence is if the rental property is contiguous to the primary residence.
Yeah.
It doesn't sound like it is, but that would make a difference.
Yeah.
If Alabama's definition of primary residence includes that, like Tennessee, most of them do. Most states do.
Right.
Because the states mimic their rules after the federal rules, so they all have some similarities.
Yeah.
But and so, let's see. I guess the question about that, they say, we talked about primary residence versus other real estate, both husband and wife being in there. What that really means is, now the ability to transfer it from one to the other is not available because they're both in
Right.
care, which is how you can escape estate recovery. You just transfer ownership to the community spouse, which is the healthy spouse at home.
Sure.
The trick to escaping the state recovery is to pass away with no indicia of ownership. Now, in Tennessee, we have right of survivorship, and at the moment of death, husband and wife, right? And we'll pick on you, Jeff.
Yes.
And say, you own your house, you and Teresa own it with right of survivorship.
Yeah.
And you do.
Yeah.
At your death, all ownership instantly vests with the survivor. So at the
Yes.
moment of your death, it all belongs to Teresa.
Yeah.
Now, you can argue, did you pass away with an ownership interest? Well, but if it went away instantly, did you or did you not? Well, the courts have answered that a while back in a case, say something versus Jones, and they said Yes, that's an indicia of ownership, and that will trigger estate recovery for that piece of property owned with right of survivorship. So the trick is, when you pass away, don't have any ownership. I mean, I'm not gonna get into that, but I talked about that many times before, but what we do is we change ownership. There's a time to do that and
Right.
and a time not to do that.
Right.
In the process, the
Right.
eligibility process, so
And that's,
hopefully that answers the question.
that's part of the asset protection stuff, so.
And I just am a little leery about giving, I don't want anything to be construed as legal advice on a radio show, especially in another state.
Right.
And I have to say that perhaps I ought to read a disclaimer, because what I'm getting at is, I can talk about stuff, but when I talk about stuff to the listeners, it's not legal advice, because if you want legal advice from me, I'll give it to you, but it's gotta be based on your circumstances,
Right.
your dynamics, and I'll give you a written opinion, and I'll stand behind that.
Right.
So if you hear something I say, don't run out and do it, because
Right.
you're not getting the whole story, and I don't know if it applies to your facts or not.
Right.
Okay, so I mean, if you want to know if you hear something, hey, it sounds like something good I should do, call me and we'll talk about it.
You wanna take a follow-up on that?
Sure.
Okay.
I mean, I think
Whoops.
I
There it
covered
went.
everything.
There it went, all right.
I think I covered everything.
All right, that
But
was
it's a
just-
concept that, it comes up a lot, so
Yeah.
I see where the question,
Yeah.
has come up, and
All right.
hopefully it will help.
All right, well, so you must have a follow-up.
Yes, I want to follow up with this because this is the second time he's cautioned me about not giving legal advice. I'm not a lawyer. All I do is tell these people, this is what I heard, and you need to check with your lawyer. And I want to know, where is the line drawn? Because I ran into this with HIPAA out at the hospital with my mother there. And a nurse tried to tell me that I could not discuss what was wrong with my mother with anybody. And I was the power of attorney. I was at the library yesterday. I gave you a list of questions to ask your doctor. They're not like I'm giving medical advice. And the worker at the library told me she couldn't help somebody with a question like how to figure out how to use the computer to get it. Now, it seems to me like if people have to cross their palm with silver like a doctor or a lawyer to give legal advice and be a client, that someone that's a family member, and I was of the second, or a friend, that I can discuss things that I've heard on the radio. I just wonder what his opinion is about that, because I think this is, I know what he's talking about, protecting himself and protecting a legal opinion. I don't give legal opinions. I give my opinion as an individual that has a friend or a relative. And I knew a lot about HIPAA. What she was saying at that time, which is not right now, absolutely didn't apply to me. Unless I had looked at the medical records or something like that, and my mother had told them to tell me not to.
Okay, all right. Well, there you go.
Okay, well, I mean, she's right. I mean, I'm held to a higher standard than her.
Yeah,
So but I'm saying, if you tell here's what can happen as a matter of practical fact.
yeah,
Say I heard somebody talking about this on the radio, and they say you can do this and do this. If the person relies on that and acts on it, that's when you can get in trouble, because you can say, wait a minute, did I tell you to do that, or did I recommend you do that, or are they relying on your expertise?
Right.
I mean, it's all over the board what that could be. And I think she's right. She can certainly say, well, I heard somebody talking on the radio about this, and they say there's something you can do about this
Right.
primary residence versus another resident.
Right.
That's okay. I just say, be careful of the kind of advice you give. It's just out of an abundance of caution.
Yeah.
Because in a litigious happy society, I think if you are, giving out a bunch of options to do, and somebody actually acts on it, and then they suffer an adverse effect, they can drag anybody and their brother into a lawsuit like that.
well, we tend to have, we have a tendency to listen to our friends sometimes that have, had their own experiences or had someone tell them something, and they may not have all the information, and we may act on it thinking that we're doing the right thing.
Oh, and that's exactly right.
And that's
It's
what
definitely-
happens.
It's definitely an innocent activity.
Right.
And here's what I've experienced in my practice. People will come to me and say, we gave the house away to the kids 2 years ago, and now Dad's going into care. And I'll ask, I said, why'd you give the house away? And sometimes they'll say something like, well, we were talking to some people and they said that'd be the best thing to do.
Yeah.
And then they went and did it.
Yeah.
Okay, now, that's what we want to avoid. Because
Exactly.
when you're talking to somebody, or hearing something on the radio, because, you know, when I'm talking on the radio, it has to be in generalities, and it cannot be any individual person's specific facts. First of all, there's a confidentiality thing that I have to abide by, but even if that wasn't there, I don't know what the listener's individual facts are. So I
Right.
talk in generalities, concepts, options, you know, stuff like that, like the life estate thing. You know, the life estate's an option you can do. Is it something you should do? I don't know. We have to sit and talk about it for an individual.
Right.
But, you know, and I don't necessarily say, be careful, you're not giving legal advice to her so that, because I think she's giving legal advice. I just have seen so many people act on other people's suggestions because it's a radio caller telling me facts, and I really, in reality, have no firsthand knowledge of that individual's facts. And so
Sure.
I don't want that to get relayed from one person to another person, then to the third person, and then maybe them act on it.
Yeah.
It could end up being adverse. I don't know. So, I mean, and I don't say you need legal advice to proffer the legal industry. I mean, there's a lot of things you can do on your own in law, but in this area, I kind of think it's better to deal with somebody that understands the rules, because the rules are voluminous and confusing.
Yeah, they are.
And then even if they were unambiguous and clearly written, then you have to deal with the individuals, with the organization that
Sure.
make things difficult
Sure.
and ambiguous. So certainly not for do-it-yourselfers, in my opinion. Although you certainly can do every bit of what I talk about as on your own what they call pro se.
That's one of the most common things that I run into with the real estate deal is I say, well, you know, we deeded that to our kids a long time ago, or we deeded that. That happens a lot. It happens a lot, and it's because of that advice that's been out there for so long. That seems to be everybody's kind of go-to method. Let's just deed the property to our kids.
Well, and
Let's
when you-
deed the property to our kids, and it sounds like a really, really good idea.
Well, you know, when you do that, once they own it, they own it.
Yeah.
That's why people reserve a life estate.
Yeah, yeah,
And so they, you know, you say, well, if I deed to my kids, they can give me the boot. Well,
Yeah.
if somebody tells me they're going to do a life estate, I'd say there's a risk there if you don't reserve a life estate.
right.
Because once you give it to your kids, then the very next day they can say, "Thanks for the house, Dad. Now get out." Now, would they? I don't know, but they could legally. They could. Why? Because you don't own it anymore.
Yeah, it sounds unreasonable. It sounds like it would never happen, but it could.
And, well, you know, you might say, "Well, my kids would never do that." I don't know. What about the people your kids marry? Maybe, you know, those are the what ifs that you got to be worried about.
Yeah.
You know, suppose you have a child, you give it to your kid, and the kid's got a wife that says, I don't want them living there. So now the kid's like, well, I don't want to kick mom and dad out, but I don't want my wife mad at me.
Right.
I'm in a rock and a hard spot. What's the decision going to be? I don't know. So most people reserve the life estate so they can live there and you can't oust them.
Right.
And again, here's another thing that goes along with, like, just let's use that as an example. I see it a lot too. People say, yeah, I've deeded the house away more than 5 years ago, so everything should be safe because it's past the 5 years. And the answer, with respect to the 5-year look-back period, it is safe.
Yeah.
Okay. If you file a 10-K application today and they say, the question is, have you given anything away in the last 60 months? The answer is no.
Yeah.
I gave it away in the last 85 months.
Right.
But not in the last 60 months. Okay, so
Right.
the answer is no, and that's right. It's out of that period.
Right.
But there's some things that go with doing that. That's called an inter vivos transfer. And it's for no consideration, or token, what we call token consideration.
Right.
Sometimes you'll see a deed that says, for $10.
Right.
That's token. The $10 never passes hands. It's token consideration because the courts allow us to use token consideration to satisfy the consideration requirement of a contract.
That's right.
And so we do that. But
That's right.
But one thing, let me just talk about that. Gosh, how can it be 10 till?
It's amazing, isn't it?
Anyway, let's just talk about that as we're getting toward the end. There's something that goes with that you may not know. And that, I mean, it may or may not be an issue. If you're giving it to the kid because you're just trying to get rid of it. Now, let's look at it from the kid's standpoint. Does the kid want the property? If you're giving it away to get it out of your estate so that they can't go after it if you go into care, you're giving it to the kid. Now, we really need to look at what the kid's going to do with it. Do they really want the house and want to hang on to it because it's sentimental? That's one thing.
Yeah.
Do they want to say, well, I'm going to hang on to it, but I'm going to rent it or something? Or if you give it to me, I'm just going to sell it, cash it out.
Yeah.
I don't want the house, I want the money. Because I live off in New Mexico, and I don't want a piece of Tennessee property.
Sure.
So if you deed it to me, I'm just going to sell it. Well, let's talk about something called capital gains tax and tax basis. When you give a piece of property, let me back up. when you own a piece of property, you have what's called a tax basis.
Yes.
Now, for most people, it's what you paid for it.
Yeah.
So let's take the parents before we gave it away. Let's say they paid $100,000 for a piece of property. That was
Right.
20 years ago, 30 years ago, who knows?
Right.
Now it's worth 500.
Right.
Okay, now, if the parents sold it, okay, we haven't transferred it yet, but if the parents sold it during life, an inter vivo sale, and they sell it for what it's worth, $500,000, they have a capital gain of $400,000. The
That's right.
capital gain is the difference between your tax basis and the sale price.
That's right.
Now, if you realize the gain, which means you still have the money after 180 days, after 6 months, right? Then you owe the capital gains tax, and you owe the capital gain tax on the capital gain, and that can be like 18 to 20% of that $400,000.
Yep.
Right? Now, let's go back to our scenario and say, let's just deed it to the kid.
Yeah.
Here it is, $10, love and affection, token consideration, here's the house. Nothing wrong with that transfer, it's a valid transfer. However, because of the way you gave it to your child, there was no bargain for sale or exchange. And because there wasn't a bargain for sale or exchange, there is nothing to compute a new tax basis for. Therefore, when you give property away inter vivos during life, your child has just received your tax basis. So let's take this same house. Your parents paid $100,000 for it.
Yep.
It's now worth $500,000.
Yep.
They deed it 5 years ago. They deed it to the kid.
Yep.
The kid's tax basis is $100,000. It's the same as the parents.
Okay.
Now, if their goal is just turn around and sell it because they don't want it, you just handed them a $400,000 capital gain liability.
Yeah.
Now, is that good or bad, or is that something they can live with or not live with? I don't know, but you probably didn't think about that when you gave it to them.
Yeah, it's something
Now,
to think about.
That's okay. Now, if they never sold it and just like left it to their kids, that would all be kind of cured, because if you leave it to them after death, so the parents don't give it away now, they leave it to them after death. Now the kids get what's called a step up in basis.
Yes.
So when they get the $500,000 house, their new tax basis is the fair market value the day of death.
That's right.
Which is $500,000 now.
That's
So
right.
if they turn around and sold it the next day, no gain.
Yeah.
But the person says, yeah, but I need to give it away, so I don't have it, and they can't come after it. So I got to give it to them during life. Well, how about we give it away during life, just like what you want, and put it in a format where they can't come after it, like an asset protection trust.
Yeah.
I mean, it's the same thing. You're giving it away. You still trigger the 5 years, but now you have it to leave to them after death, and they'll get to step up in basis on it. Way, way better way to do it.
Way better.
Both ways you can do it. Nothing prevents you from an inter vivos transfer. People say, can I transfer this during life? Nothing prevents you from doing it. There's some baggage that goes with it you might not like.
Right.
But you need to know about it before you do it. That's why I say when you talk to people, we're not getting. Again, I want to make sure. I didn't mean any offensive to the caller. I wasn't saying she was doing it. The caution just comes out of my mouth as a routine matter.
Yes. That's true.
Just because you don't want to talk to somebody and have them do something, and then maybe that's the wrong thing. I mean, it's certainly going to wreck a friendship. I don't think you'd get sued for practicing law without a license, because it's not. She's not giving a legal opinion, but she's relaying information that may be incomplete or inaccurate. I like to think my information is accurate, but it's often not complete, like that. Just like I just now.
Sure.
It didn't discuss the effect of giving away property during life and the capital gains effect.
There's so much to know, and you need to be educated in this stuff, and that's a big part of what you do with your seminars and your appearances here on the radio, and of course when it comes right down to your own personal circumstance, we would highly advise that you have that good meeting.
Your own personal circumstances and dynamics are your own dynamics and circumstances. They are different than somebody may be similarly situated, but there's differences.
Yeah.
And there's so many, it's a very complicated area of law. So many rules, a lot going on, a lot of things. I mean, you can do a lot of things, but sometimes there's other things that are working at the same time that might mitigate what we're trying to do, or might exasperate it.
Yeah,
make it better, might make it worse. It just depends. And those are the kind of facts we're talking about.
Right.
So anyway, you may have another piece of property, but you may not know it's actually part of your primary residence because of the way they define. If you use the street vernacular term and it says primary residence, you think, well, that's my house.
Yeah.
Well, maybe not. The statute says contiguous property, and there's even definition if your house is on water.
The house is what?
On water.
On water.
Yeah. I mean, there's a definition of that. Because
Okay.
the primary residence can be on a boat.
That's right. Your boat.
And so,
Houseboat.
Yep. No,
which I actually considered it one time.
I can't actually tell you what it says, 'cause I read it before and I know it's there, so if I ever need it, I'm gonna go look at it and see if it
Yeah.
applies, but, yeah.
If you had if you lived in a big RV, which is a vehicle, that's a different story too.
Yeah. We talk about talking to people, when I first talked in the beginning about how I'm being treated by
Right.
10Care on
Yes.
their blunders that
Yeah.
come to me. When you tell people to do something, I mean, and if that happens, they're just going to be lost on what to do.
Yeah.
Because those are things that shouldn't happen in the first place, but they do.
Yeah.
When you deal with law, there's the legal, there's the letter of the law, the legalities of it. Then there's the practical effect of everything. What does the law say gets done? Well, what is it that actually gets done?
Yeah.
Well, it is different. It's just the way anything can work.
Right. We got 2 minutes. Dave.
Okay.
Let's wrap it up and tell
Oh,
folks how to get in touch with you and the seminar and all that kind of
The
stuff.
clock is really behind. It's just now clicking to 56. It's 8:56, so that tells me I have 4. But I will go fast.
Yeah, this one appears where we are.
Okay, so coming up is our seminar. We do them about every other month. And the next one coming up is July the 25th. It'll be during our 250-year anniversary month.
That's
And,
right.
I'm not going to do fireworks or anything, but I may wear red, white, and blue. But anyway, that's July the 25th at 10 o'clock in the morning. We do Saturday seminars. We do it at 10 o'clock. It's called Wills, Trusts, and the Nursing Home. And that's going to be right here at the WLX radio station in the back of the building.
Right.
So if you want to come to that, you pull in the parking lot, don't go in the window, the doors up front, they probably will be locked. But in the back is a set of double doors, you can't miss it if you look for it. That's where it is, a big venue they have back there where they play music on Friday nights, you got a lot of room to set up tables and chairs. And they got a big screen TV, so that's, you can call my office at Pierchoski Estate Law, Pierchoski Elder Law, at the 931-363-7222, or go to my website, estateplanstand.com, and you can see my calendar, email me, or call me from there. If we're talking about any of the stuff we talk about, feel free to do that, or I'll call an RSVP for the seminar. It's a loose RSVP process. Just call and tell us you're coming, how many are coming. If you can't, just come on and show up. It's okay too. Walk-in's welcome.
Absolutely. I highly recommend taking up Stan on the offer to come to the free seminar. Absolutely no pressure, no obligation, but good information every time. That phone number again, 363-7222, estateplanstand.com. You can't go wrong by going there as well. And by the way, I've been by your office a time or two. You got a beautiful new office over there.
Thank you. It's
Really
neat. It's
nice.
nice. It's pretty cool.
Yeah, it's very nice.
We got a lot of room compared to what we had.
Yeah, very, very nice. I need to come in and visit.
Yeah, come on.
I need to come in and visit. Teresa and I are probably going to plan a visit with you fairly soon.
Okay.
We've been talking about that. We got to plan on some things ourselves, so we're working on it.
That should put us right at time.
We are time.
Okay.
Thank you, Stan.
Always a pleasure.
We'll be back next time, next Friday, and good to see you, my brother. We'll see you next time.
Serving Lawrence County since
Close.
1951. This is
Clock's getting more and more off every week.